Hi, I'm an avatar from the law office of Daniel Horowitz. Recently, we have seen police seize guns after an emergency protective order has been issued. An emergency protective order is also called an EPO, and it often issues in domestic violence cases. What happens is that the police are called and they determine who the main aggressor is. Sometimes the person who threw the first punch or pushed first is not considered the main aggressor, but that is for a different video. The seizure of guns is a Second Amendment issue, and in California it is also a statutory issue. The Second Amendment protects your rights to own and use a firearm. The California statute is the rule of law that allows the seizure of guns if you are accused of being the aggressor in a domestic violence situation. In California, once the main aggressor is arrested, the police will call a judge and get an emergency protective order issued. This EPO tells the arrested person to stay away from the person who is identified as the victim. Most orders also require the person to turn over or get rid of his guns. Lately, we have seen police officers seize guns that are in the home because they believe that the protective order permits this. There is an entire discussion about whether the Second Amendment protects a person from surrendering guns just because he is accused of a crime. Whatever happened to the concept of innocent until proven guilty? But this video focuses on California law as it relates to emergency protective orders. We will save the Second Amendment discussion for another time. Here is the law in California. The emergency protective order does not allow police to seize guns. The proper method for police to use if they want to seize guns is to obtain a gun violence restraining order. This is a special order, and it is more difficult to obtain than an emergency protective order. Without a gun violence order, the police can't seize the guns. Hold on though. Obviously, if a gun was part of the crime that led to the arrest, the gun can be seized as evidence. But this video is about a situation where the guns seized are owned by a person, but were not used as part of the domestic violence incident. The law that allows for a restraining order says, the court shall order the respondent to relinquish any firearm. This means the person who is the subject of the order is the one who has to turn over the firearms. Let me emphasize this point. It is not the police, it is the person who has been arrested who has to act. The person must be given the chance to turn over the firearms or otherwise dispose of them. If the police disobey the law and take the guns, they must be returned. There is a case in California whose title is People versus Superior Court. It is also known as the Corbett case. This case threw out a search for guns because the prosecution did not show that Mr. Corbett was given any opportunity to relinquish his firearms or arrange for their surrender before the police searched his home. I hope this video was helpful. Hi, I am an avatar from the law office of Daniel Horowitz. Today I am discussing an important issue in criminal law. That issue is whether social media posts be used against a defendant at trial. A recent federal court case said yes. On December 19, 2025, the U.S. Court of Appeals for the Ninth Circuit issued its decision in United States v. Justice. The court affirmed the conviction of Robert Alvin Justice Jr. for his role in a shocking ambush that killed one federal security officer and wounded another during protests in Oakland, California. The case stems from events on May 29, 2020, during widespread protests in Oakland following the murder of George Floyd. Justice drove a van past the Ronald Dellums Federal Building, where two protective security officers employed by the Federal Protective Service were stationed outside providing security. From the passenger side, Justice's co-defendant, Stephen Carrillo, who, by the way, was an active-duty U.S. Air Force sergeant at the time, opened fire with an assault rifle. The attack killed one officer and seriously injured the other. Carrillo, linked to anti-government Boogaloo extremist ideology, later killed a Santa Cruz County Sheriff's deputy in a separate incident. Justice pleaded not guilty and was convicted after trial on charges including murder of a federal officer and attempted murder. He appealed to the Ninth Circuit, challenging aspects of his conviction. One aspect that he challenged involved the admission at trial of dozens of Justice's personal social media posts. Prosecutors introduced these posts to show his interest in violence, anti-government sentiments, and ties to the Boogaloo movement. They did not use the material to show that he was a person with a propensity toward violence. That would be prohibited. They were more specific and used the posts to demonstrate motive, intent, and premeditation. Justice argued that the evidence was irrelevant, constituted improper character evidence under Federal Rule of Evidence 404, and was unduly prejudicial under Rule 403. The Ninth Circuit rejected these challenges, finding that the district court did not abuse its discretion in admitting the posts. The evidence was deemed directly relevant to proving Eustace's shared ideology with Carrillo and his voluntary participation in the attack, rather than mere bad character. This ruling aligns with broader federal practices where social media content is routinely admitted if properly authenticated and relevant.
Daniel Horowitz is a trial veteran with over 200 jury trials to verdict. He assists and consults with attorneys who are expert in their field and takes private cases for clients as well. Call Daniel Horowitz at 925-283-1863. Again, our number is 925-283-1863. I hope this video was helpful.